Ms. Graham.
Just before lunch, I was asking you questions about the issue of the speed at which officers elected to use force in relation to Mr. Bio. And I was about to come on and ask you, against that background, about whether you directed any lines of investigation or instructions to be given in relation to that issue of unconscious bias, and how unconscious, particularly how unconscious bias could manifest itself in the actions and behaviour of individuals.
I think the investigations that were taking place around that unconscious bias were directed initially at the background of the police officers, so that was the part that was informing me about their potential thinking. The unconscious bias that I was looking at, or potential areas I was looking at at how the actual restraint played out, was in the specific actions of the officers, and that of course fed into their decisions that they made at particular times.
Right.
And you asked me specifically if I gave any particular instructions. I gave instructions with regard to the restraint expert. My recollection was that it was me that specifically said we needed someone to look at the restraint aspect, because I felt I didn't have enough information. I saw in the documentation that I looked at in preparation for today that there was a discussion about going back to one of the other experts to see if we can get a bit more information, and I had indicated in the particular email that I'm thinking about, which I think was in the 2017 batch of emails, particularly the 29th of November 2017. It was an email from me, either specifically to Les Brown or to the team, in response to a suggestion that we should go back to one of the other experts to explore that area. And I indicated that I still thought we needed a further OST expert to explore the specific details of the reactions of the officers.
And was that in relation to the restraint and the actions taken by the officers regarding restraint, or was it specifically in relation to unconscious bias?
It wasn't specific. Something wrong with my microphone. I don't know.
There's some feedback here.
I did wipe my screen at lunchtime. I might have moved it. I've lost my train of thought now. You were asking me about the officer and restraint and the OST expert.
Could you maybe wait for a second?
Sure.
I think the cavalry have arrived.
Just move this a little bit.
Okay.
Thank you.
Thank you.
So you asked me about the instructions and whether it was specifically to do with the restraint. It wasn't just the restraint.
I asked you if it was specifically in relation to unconscious bias.
Okay. It was part of that information that I would get from the reactions of the officers would feed into their potential for unconscious bias, so their mens rea.
Did you investigate or direct the team to investigate the issue of unconscious bias?
No, I don't think I ever said specifically that those words, unconscious bias.
When you've told us how you were considering the issue of mens rea and the mental state of the officers. In relation specifically to unconscious bias, did you explore this with any expert that the Crown instructed?
I think, as we've discussed earlier, what I saw was the source material for unconscious bias would be the surrounding facts and circumstances and a full analysis of the decision-making process and whether those decisions were reasonable or not in the circumstances. And all that information would allow me to analyse the mens rea and the potential for unconscious bias.
But did you feel yourself that you were in a sufficiently trained and educated place at that time to analyse the question of unconscious bias?
I knew about the concepts. I knew what to look for. Was I an expert in the field? Absolutely not.
What were you looking for then?
I was looking for the actions of the police officers, whether they would be the action of a reasonable police officer. If the answer to that was these were not the actions of a reasonable police officer given the set of circumstances, why not? What things were causing that officer to act unreasonably?
And did you consider unconscious bias as one of those things?
Of course, because the fact was that Mr. Bio was black, and so that was part of the factual matrix that I was looking at, and as to whether the decisions that they made were affected by any racist views that they might hold, consciously or unconsciously.
And you said a moment ago that you are not an expert in the field, and did that in itself give rise to consideration on your part that you should seek some assistance from an expert in the field?
It didn't, but subsequently I have thought that perhaps might have been something that was useful, and I've already said to the inquiry this morning, in another case that I was running almost at the same time, it was at a much later stage, it was a trial, I did have an expert and I consulted at length with that expert, and that expert assisted greatly in explaining some of the material which had been recovered in that case, and about right-wing views and the history, and just a broad knowledge of that particular topic, and it may well have been that that's something that we should have looked at.
So, given your subsequent experience with that expert, looking back now...
I think actually it might have even been before, because I think that might have been the trial that I was doing in the July. So that's in between issuing my final CCI.
So in a previous trial you had utilised and used the assistance of an expert in relation to issues of bias or discrimination. Why then did you not consider using that in this matter in relation to Mr. Bio's death?
In that other case, there was a massive amount of material that was covered, and that material I really needed assistance in explaining what it all meant and to put it all into context. We didn't have that material here.
But in a situation where there's a limited amount of material, or the material is not obvious to you, not being an expert, does that not make it more important that you seek out the assistance of an expert who may be able to identify relevant evidence and assist you? Important not to miss anything.
Well, as I've already said this morning, we were really alert to not missing something. We were following all lines of investigation. With hindsight, I can now see that it might have been of assistance to have an expert come in and give me a general overview about the types of issues, to talk about racial stereotyping or racial tropes. It might have been a good idea to have someone in just to give a very brief report. It might not have been something that we would subsequently use at a trial, because there was no material to base it on at that stage. So, for example, the trial that I'm talking about, there was a great deal of written material which was used in the trial and required the expert to assist the fact finder. What I think you're maybe anticipating or asking me about is whether that's something that might have assisted me at the time, or the team.
Possible, of course, that there may have been material, you not being an expert, there may have been material you overlooked, didn't see that was there. an expert could perhaps have helped you to flush that out.
Well, I don't think there was any material that we didn't have, because we followed everything that we could get with regard to the actual factual matrix. I was satisfied at the time that I was in a position to analyse all the material that we had. Would it have been of benefit for me to have that extra layer for an expert? Possibly. I can see now with hindsight, yes, that might have been a good idea. Would it have made any difference in my analysis of the factual matrix? I'm not sure. I might just have been better educated about it.
I'm not asking you to second guess your decision. But if the Crown were wishing to pursue all lines, then the issue of unconscious bias could have been pursued at the time. You had experience of using an expert in a previous trial, but that wasn't something that you did on this occasion.
I think unconscious bias was pursued. Did we have an expert to that effect? No. So I think there's a distinction there. I think there's two answers to that question.
Okay. Sorry, I'm just reviewing my notes there. Can I move on, please? You've mentioned the phrase racial tropes, and we've heard evidence from a number of witnesses in the inquiry where we have talked about racial tropes. We have heard evidence, first of all, from Fiona Carnan, the precognoser, that she made no reference in her analysis of evidence regarding the use of racial tropes or negative stereotypes. She took the view that evidence about negative attitudes of officers to Mr. Byles' race would not be relevant to the analysis unless criminality was identified. And I think I explained to you this morning that she had taken the view that unless there was criminality, at which point she would consider a racial aggravation, that was the only situation in which she would consider race as being relevant. And she, not having found criminality, didn't look at race. We have heard evidence that there was information available within the officers' statements that they gave to PERC on the 4th of June 2015, that some officers were concerned they were attending a terrorist incident. And there were a number of comments about the threat level that was in place at the time. Some officers made comments about concerns about an attack on police officers. One of the officers talked about, it ran through my mind that this male could be part of a terrorist plot. And in evidence, Fiona Carnan was asked about these comments within the officer's statements, which she had, whether she considered why there was a possibility of terrorism that had crossed the minds of officers. She was asked, did you consider whether they would have thought about terrorism if Mr. Byles had been white? She said no. She was asked, did she consider whether they thought about terrorism every time they went to a knife call? She said no. She was asked why one of the officers, Constable Payton, had thought about Lee Rigby in particular, and she said she simply noted that. She didn't give it any thought as to why he thought about Lee Rigby, and she said, I didn't interpret it as being influenced by his race, no. She was asked if she'd considered whether Constable Payton would have been thinking about Lee Rigby if Sheku Byles had been white, and she said, I didn't ask that question. And she was asked, did she consider whether there was evidence from which the inference could be drawn that the colour of Mr. Byles' skin was relevant to the concern that the incident was related to terrorism, and she said, I did not make that assessment. Now, you've explained earlier today that you had the officers' statements and you read them. And you've said a moment ago you felt capable of making assessments regarding unconscious bias. Did you ask yourself these questions?
Yes, is the short answer.
And when was that done?
All the way through, right from the beginning, you're looking and analysing, as I've set out this morning in my evidence to the inquiry, you're looking and analysing and seeing if you can find answers in the factual matrix. I have all the source material. The fact that in her own mind, the person who prepared the analysis was not asking those questions, that didn't mean that I was not able to ask those questions. In fact, that was my job.
And so in this process of when you were asking all these questions about the content of the officer's statements where terrorism is mentioned or the possibility of that is mentioned, did you prepare a paper which set out what each individual officer said about terrorism or any connection they made with terrorism, and whether there was any further explanation within the statements about that?
No, but I had the statements available, so I would be looking at the information that I could get. The ideal thing from the point of view, my point of view, would have been to be able to ask the officers themselves, because those are the kind of probing questions that would give me a real insight into their thinking. But I was limited to what I had on paper, and so I was looking at the information that I did have, together against the background of the further information that had perhaps some of it had put certainly me for sure on alert with regard to the history of particularly one of the officers.
I appreciate you only had the statements to some extent. Did you ask for any lines of investigation to be explored to see how often officers attended knife incidents?
No. I didn't ask for any of those comparative exercises.
Did you ask about how often they'd attended knife incidents and drawn their batons?
No.
Used their sprays?
Now, my recollection was that there was some information with regard to the use of sprays, and that was in the history of each officer. That's my recollection. I think on some occasions the forms weren't filled out entirely correctly, but I understood that every time you used your PAVA or CS spray, there was a proper post-incident analysis and record keeping, or supposed to be, with regard to the use of that spray. And my recollection is that I had that information as part of each individual officer's records.
Did you consider a line of investigation into looking at the use of force by the individual officers, where the subject had been a black man compared to where the subject had been a white man?
No, I didn't ask for those further investigations to be done.
Did you consider comparing their individual responses to knife incidents where they'd used spray, used force or not, and any comparison with whether the subject was a white man or a black man?
No, I didn't consider asking for that information.
The fact that there was no analysis of this done by Fiona Carnan, which she's accepted, did it surprise you that that hadn't been explored or addressed in any way in the work that she had done?
I suppose it did surprise me because there was a great deal of focus throughout the 2 years on the issue of race and how it could fit into the factual matrix. But I took that on board, along with the fact that the person who prepared the analysis only really came in towards the end, and she was looking at the information. She didn't live with the case throughout it. She was looking at what was down on paper.
Well, you thought that excused a failure to address race in any way?
I'm not saying that it excused it. it was certainly a reason. If the analysis was not as full as we might have expected, if it had been done by a person who was in the team right from the beginning, then I would see that there was potentially a reason for that.
Do you think there's merit in the same person or persons being involved from the beginning and being involved in the narrative and the analysis, and not to have those two aspects separated?
Absolutely, 100%. I don't remember whenever that's happened before. If it has, it's only been on one particular occasion, and I think where the roles have been separated out, but I still think that the person who was doing the narrative was still involved in the next section. It's usually just one person or the team, everyone prepares it.
Do you think there is a disadvantage if the roles are separated and different individuals are responsible for the narrative and the analysis?
I think so. At the time, I was not particularly involved in resourcing and the amount of people in a team. I did recollect that I was trying to push it forward, not just for my own timetable, but also because of the time elapsed since Mr. Bio's death. And so I was pushing to have more people on it so it can be completed. But yes, there is an absolute advantage to having the same team all the way through. I'm also aware that there were a huge amount of other large inquiries and only a finite amount of resources.
You've talked to us about Article 2 and the responsibilities in relation to Article 14, and I explained to you that we'd heard that others had agreed there was a duty to identify racial motivation from the beginning with in relation to this type of case. In light of what you knew about the obligations under Article 14 and Article 2, did you not consider that this was a topic that should be explored in the Crown Recognition? That it shouldn't be left to the Advocate Depute, the allocated AD, to consider issues of race, racial motivation, unconscious bias, with no mention of that in the analysis at all?
Did I think about it at the time? No, I don't think I did. Now that you're asking me the question, yes, it might have been an idea for me to go back, but by the time the analysis is being prepared, I've already lived with the draft narrative for quite a while. I've lived with the source documents. I am trying to get to a stage where I'm in a position to make a decision, and so the narrative, the analysis is perhaps coming at quite a late stage. It's often in an allocated case, as you pointed out this morning, the precognition comes to you, and that's the first that you know about. I had been involved towards the latter stages anyway in the site of the draft narrative, the timeline, the multimedia, the body positions. I had seen the bulk of the expert reports. So by the time that Fiona Carnan is coming to prepare her analysis, I'm already quite far into my reading. So I didn't think about saying to her, can you go back and change that or add to it? Because I'm already there. I'm already thinking about those things.
We've asked Stephen McGowan about this and Lindsay Miller about this. And Stephen McGowan said his view was that it would have been relevant to ask why it was that the officers thought it was terrorism, and to consider whether Mr. Bio's race had anything to do with that. And whether or not, had Mr. Bio been white, they would have wondered the same thing. That's a relevant question. And Lindsay Miller agreed that was a relevant question to consider, this motivation. Was it a racial motivation? They recognise it was relevant. Fiona Carnan didn't do that. You've come in looking at the precognition. It's not there. It's not been analysed. It's not been considered on the face of the paper. but you are going to go through that process. Is there anything written down by you, any notes? You know, there's mention of a notebook that you've had. Any notes or anything at all where the chair could look at your analysis of this issue to do with racial motivation?
No, I don't think there's one document that I can point you to. I think throughout the notes, my to-do lists, my notebooks, there are to-do lists of things that I want answered or questions that I'm obviously asking myself. And a significant amount of those notes go towards the actings of the officers and their motivation. I can't point you to a particular document that says, I am looking at race here, I'm looking at unconscious bias, I'm looking at racial stereotyping. There's not a document that I produced, and we talked about that before lunch, because one of the things that I might have done if I had thought about that or thought it was necessary was to ask the Crown Council trainee to go away and provide me with some source documentation so that I could then produce a note on it. That's not something I did. It's something I've done in other cases, but not this case.
Cases that you dealt with before the case involving Mr. Bayo's death?
Before and after.
So we've heard that there were a number of officers who attended, described as 9 attending officers. They gave statements. Some gave more than one statement, some had self-penned statements, some they gave statements to PERC. And they're of varying lengths. When you were considering the issue of terrorism and the issue of bias or potential bias, was this all going on in your head? All these questions just being asked in your head? There was nothing written down as you went through the statements?
There might have been notes on the statements. There's certainly notes in my notebooks. I can see notes on the narrative. I can also see notes on some of the expert reports. So there are notes, but there's no official Crown Council analysis of a particular area involving race.
Do you remember any of the notes? So we've seen notes in margins and scribbles. Are there
Fortunately,
any?
that's my writing.
Sorry. Are there any areas in particular where you recollect considering these issues and noting anything down at all?
I was aware from an earlier stage about the threat level and the potential briefing. So I'd seen that in the statements, and there was further work done on that. I'm not sure if there was an exchange of emails, but certainly there was further work done with regard to the factual basis for that information and exactly what the officers had been told.
I'm interested in the comments within the officers' statements about a potential terrorist link, Lee Rigby, terrorism, that type of thing.
That's how I found out about it, because it was in the officers' statements.
Yes. Are there any notes that you recollect making, whether in a margin or in a notebook, that would demonstrate to the chair that you have gone through this process of analysis in relation to issues regarding racial motivation, primarily connected to comments about terrorism or potential terrorism in the officers' statements?
There's nothing that I can think of. That's not to say that they're not there, because I did go through that process and I may well have made notes. But there's nothing that I've reviewed for giving evidence in a way that I've managed to point you towards documents. Beyond my notebooks and my to-do list, which tell me what I'm thinking at the time, it reminds me of how I approached it.
Was there anything that you saw from the documentation you were given that reminded you that you'd gone through this process?
I'm just trying to think, because I've seen a lot of documents over the last few days. Some of it I just went through very quickly because I didn't have a lot of time. Some of it is the information I looked at was notebooks, and I've seen the lists in the notebooks. There are also, as I said, notes attached to expert reports, and there are quite a lot of emails. I've been through those. There's no annotations, obviously, on the emails because those were electronic documents. So beyond the content of the emails, I don't think there's any handwritten notes that would assist.
All right. Let me ask you about another entry in one of the PERC statements. This came from one of the officers, Kaylee Good. And if you've listened to other evidence, you may be aware of this. PC Good had also talked about Lee Rigby. She said, I was also thinking at that point of the Lee Rigby incident in London, mainly due to the fact of the coloured male and the potential terrorist connotations. So it'll be a matter for the chair, but it appears she makes a direct link between the colour of Mr. Bio's skin and the thought of terrorist connotations. Was that something that you took into account when you were considering the issues of race?
Yes, because that was part of the whole area that we looked at with regard to the briefing, the comments about Lee Rigby. I went back and refreshed my memory. I think I've seen on a couple of notes that I've made that I've put Lee Rigby ? And then I recall going away and having a look on the internet just to remind myself. So yes, that's something that I looked at, I factored in. At the time, I don't think I called them racist tropes, but I was aware of racial stereotyping, the big scary black man or the angry black man. So I was aware of those types of racial stereotyping. And I was aware that there could have been a connection between the colour of Mr. Bio's skin and the connection with Lee Rigby.
And when you were considering issues of mens rea, as you've described, and the mental state of the officers, to what extent were you factoring in these entries from, for example, Miss Good's, PC Good's statement?
These are the only things that I had to work with. So that and the background information were the things that I had to work with. As I've said before, the ideal would have been able to go and ask the officers, to question the officers, to probe, to understand better, but that was not something that was open to me. It would have been something that would be open at a later stage.
We asked Fiona Carnan about this entry in PC Good's statement, and she was asked about whether it caused her to wonder whether PC Good or others had thought about terrorism and Lee Rigby because they'd done so because of the colour of Mr. Bio's skin, and she said no, she hadn't considered that. No, I didn't, she said. So she didn't consider that at all. Was there any discussion between you and Fiona Carnan about these issues that were in the statements?
No, I didn't have any. My recollection beyond simply touching base, I didn't have any discussion as I can recall with Fiona Carnan about the analysis, except to find out what the timelines were. And I had a look at one of the meetings, I think, in Hamilton in the January of 2018, and there is a discussion about the timeline, not the incident timeline, but the timeline for the preparation of the precognition. And there's an indication of me asking for timelines with regard to the narrative and the analysis. And I'd been given dates at that point, I think, for the receipt by me of the final narrative and the final analysis. And from recollection, I don't think that it was anticipated that they would come together, which is not ideal.
No, you mentioned a moment ago racial stereotyping. Mm-hmm. Explain to us what you were looking for when you were looking for racial stereotyping.
examples of what I just explained, the angry black man or the big scary black man, and there were elements here of both those things in the statements of the police officers.
And were those factored into your analysis, your own personal assessment of the paperwork?
I'm not sure what you mean by the paperwork, but they were factored into my assessment of the information that I had. Right. The statements, the further investigations that had been done, the background information, the disciplinary records, all those things were things that I was looking at, were looking for.
And when you found examples of what you considered to be racial stereotyping, and you're obviously assessing and considering the issue of racial motivation, mens rea, what did you do with that information? Did you gather it together and consider it separately, or?
It all factored into my final analysis of all the papers, but also informed me with regards to what I would need from an OST expert. And that, I think, brings me back to the idea that I wasn't satisfied that the expert that we already had, who I don't think was particularly a restraint or an officer training expert, although I had agreed that that expert, whoever he was, I'm sorry, I can't remember, we should go back and ask some further questions. I did form the view that with the information I had, that taking a re-recognising that expert wasn't sufficient, wasn't going to take me far enough.
And in terms of the process that was followed in Crown Office at this time, we've heard from James Wolfe that he was provided with a narrative and an analysis, and that he had a meeting with you. And in terms of the process you developed in your role as the allocated AD, was part of that to explain your thought processes about racial tropes, potential terrorism, racial stereotypes? Is that something that was addressed?
My recollection is that I had a set of hard copy papers, so it wasn't electronic, it was a full set of papers, which I think perhaps is supported by the fact that I've got, my writing is on the narrative and the analysis, and presumably, although I haven't seen them, the statements. So here, and I've got to be careful not to mix this case up with the one that follows, my understanding was that there would be a significant input from the Lord Advocate, and that he had the full set of papers and was going to review them. I want to be really careful that I don't mix it up with the M9, which came afterwards, because the same situation was there, and I can't remember whether it was understood by me that he would actively look at all the papers, or whether that was the case afterwards.
Forgive me if I'm wrong, but did the issue of race or racial motivation arise in relation to the M9?
No,
no.
It's just the process that we're talking about, because this is quite an unusual process. Mm-hmm. Even in the big allocated cases, advocate deputies routinely make decisions without recourse to the law officers. Mm-hmm. But this was a different case. This was a case that had significant law officer and senior civil service involvement long before Crown Counsel was involved, and that was carried throughout the process. So much so that my contact with the family was not the normal court process, because there had been something else running and in place before I came in.
Talking about this process or the procedure that was adopted here, if we, for these purposes, assume that the Lord Advocate, James Wolfe, did have a full set of papers, that he had the narrative, he had the analysis, and the full set of papers. He had a meeting or a number of meetings with you. He had your Crown Counsel instructions to consider.
A report. Although I said it's Crown Council instructions in my statement, it was a report. Once I had access to the materials, I could see that it wasn't a CCI, it was a report.
It was a report. And you'd said in your statement you had a number of draft CCIs. Was that a number of draft reports?
Yeah, they weren't draft, they were just reports. Right. They gave rise to the final CCI. I had it in my head from memory that I had produced simply a draft CCI, so this is the instructions I'm going to give, and looking for law officers' authority to give those instructions. But actually that's not what it was a series of reports.
So those papers have gone to the Lord Advocate. He has your reports, but what he did not have was the advantage you had of your involvement since 2016. He hadn't attended consultations with experts. He hadn't directed lines of investigation. He hadn't been involved with the precognoser, the solemn legal manager, or any of those people.
Agreed.
So you have had that advantage. We appear to have a situation where the precognoser has prepared an analysis that does not contain a detailed analysis of race or racial motivation or any of that. There's no analysis by Fiona Carnan of racial tropes, racial stereotyping, any of that. And that's evidence we've heard from her. But you have given evidence today saying you were considering those matters from the beginning. How did you plan to share your thought processes on racial motivation and the analysis that you'd applied with the then Lord Advocate who hadn't got that benefit?
I don't think I separated that out into the analysis of the individual parts of the mens rea in order to provide a more detailed report to the Lord Advocate.
And why was that?
I didn't think of it at the time. I thought my report was detailed enough for the Lord Advocate to use as a starting point, and he had the full set of papers. Now, of course, I wasn't expecting the Lord Advocate to go away and look at all the source material and to know all the information that I had gleaned over the previous 2 years. But I had understood that I had been chosen to be the allocated advocate depute, and that was because of the experiences I had, and I had understood that I had the confidence of the Lord Advocate to make those decisions in his name, and that if he had felt that there was something missing in the information that I provided to him, he having of course had the benefit of information again throughout the life of the case, because the Lord Advocate, the law officers, were regularly updated through law officers briefing and minutes. I was confident if there was something that he was not satisfied with, he would ask me. Right. If I had thought about it and thought perhaps it was necessary to put it in writing, then I would have done it. With hindsight, it might have been a good thing to do.
Was there anything in writing from you to the Lord Advocate regarding race and racial motivation?
No, I don't think so. Apart from my report to the Lord Advocate, and I can't now remember what that specifically dealt with.
So we've heard a number of witnesses explain how race was very significant from the very beginning. And as I've said to you earlier today, it's been accepted that rooting out racial motivation, there's a duty in relation to the investigation itself that be done. Given the importance of race, how was it, and given you were not going to prepare a separate report on race, and given Fiona Carnan didn't deal with race, and that was countersigned by Les Brown without addressing the issue of race, How was the Lord Advocate expected to become aware of race and racial motivation issues insofar as they related to this investigation?
Well, he had all the material, he had the narrative, he was able to, he knew the steps that the investigation team had carried out. He was aware from the beginning that race was a feature of the investigation, and that was one of the things that underpinned all the avenues of investigation that we undertook.
But we've heard that there was nothing about race in the analysis, and there was nothing about racial tropes or racial stereotypes which you were able to identify from the statements of the officers. Was it your expectation that the Lord Advocate would take those papers and read through them all himself and make his own assessment, as you say you carried out, about issues to do with racial motivation?
I think it was my understanding that he would be satisfied that I had gone through all the correct processes, and that if there was anything from the narrative and the body of my report which caused him concern, then he would ask for further work to be done in the same way as I had done when I was preparing my report and reading the precognition.
Was it your expectation that the Lord Advocate would say to you, why is there no mention of race here?
No, because if I thought he was going to ask me that, I would have made sure that I'd done it in the first place.
Right. So why didn't you do it in the first place?
Because I was doing it as part of all the information gathering. It was something that was overarching.
But not mentioned in the paperwork?
I think analysed out, no, but it was being looked at in all the information that we were gathering. I'm not quite sure, beyond mentioning racial stereotyping or racial tropes, how much more could have been said if we were actually looking at those areas.
Did you consider what inferences could put, I'm not asking you what you did, but could you have considered what inferences could have been drawn from the existence of racial tropes, racial stereotypes, links being made to terrorism? Did you consider and ask yourself that question? What inferences could be drawn here?
I think if I'd got to the position where the factual matrix had led us to the point where the actions were unreasonable or not justifiable or unusual or out of the norm, then that would have required that next step. It's not that we weren't asking the questions, but once you have the actus reus of a crime, then you want to look at the mental element.
Did you consider whether the actions of the officers were justifiable?
I did, but I needed help with that, and that's why we wanted the further expert. It had been dealt with, I thought, on a less than satisfactory level for my purposes in the experts that we already had, and I didn't think that what we had went far enough. My recollection is that we didn't get round to have the ability to instruct the OST expert till quite late in the day. That was partly because of the continuing analysis of the expert information that we had, but also partly because of the difficulty in identifying a suitable expert.
Looking back now, are you satisfied yourself that all the steps that were taken as part of that Crown recognition process, by you, by other members of the team, that all reasonable steps were taken to unmask any racist motivation?
I've thought about this quite a lot, and I have to say that my overriding feeling when I came out of the investigation was that we went above and beyond what we would normally do, extra. And that felt a little uncomfortable because it felt like that's not something that we should be saying when we're looking at different investigations. But perhaps now looking at it with hindsight, that is what we were doing. We were going that extra mile to try and unmask something because we were following things in a pre-petition recognition in such detail that we might not normally have done if it hadn't been the circumstances that were facing us. So that, I have to say, is with hindsight an explanation for my feeling that when we came out of the investigation that we really went further than we would normally do.
Certainly we've heard from Mr. Stephen McGowan, and he was asked in relation to this. So he said, with the benefit of hindsight, did the Crown investigation take all reasonable steps to unmask any racist motive? He was of the view that he thought further steps could have been taken.
Well, what I've already agreed with you is that one of the steps is we could have had an expert in to inform me and the investigative team about racial stereotyping, racist tropes, unconscious bias. That might have been helpful, and that might have been a step where we could have said that that's something that should have been done. Would it ultimately have assisted in my assessment of criminality? I don't think so.
I don't need to ask you that question.
Perhaps it's a step that we might have done at the next stage, but would it have been helpful at the time? Possibly.
So would it have been reasonable to perhaps seek out further expert assistance in relation to identifying racial motivation?
I think with hindsight that might have been a good thing to have done.
And certainly I think Lindsay Miller also gave evidence, and she described that there were other opportunities for exploration that could have been carried out. I asked her, or my learned junior asked her, with the benefit of hindsight, do you consider that all reasonable steps were taken to unmask any racist motive by the Crown? And Lindsay Miller's evidence was, I think on the basis of Miss Carnan's evidence, no. Would you disagree with that, knowing what I've told you about Miss Carnan's approach?
If you were asking her that discrete question on the basis of the analysis, then I don't disagree with her agreement on that. I do disagree about our general approach and the wider investigation.
I'd like to move on now to your consultations with the experts, but I'm conscious it's 2:55 and we often have a break at this time.
We'll take a 15-minute break. Ms. Graham.
Thank you. Before the break, we were talking about when you had prepared your reports, or draft CCIs as we were calling them before, and you'd spoken to the Lord Advocate. And I asked you about what you'd prepared in writing, and you've explained your position on that. Can I ask you, when you met with the Lord Advocate, did you have a discussion or raise the topic of racial motivation with him?
I can't remember the meeting with the Lord Advocate. I can't remember any details. I remember the lead up. I remember sending the materials to the private office. In fact, I think the private office asked me for the materials. I saw somewhere in the emails an email to Giles, who was at that time the private secretary to the Lord Advocate. So I remember sending in the papers. I remember Lord Advocate asking for a meeting. I remember that there was further work to be done after that meeting, but I don't actually remember who was at the particular meeting, whether it was just me and the Lord Advocate, or whether it was the whole team.
When you say you were asked to send the materials, what do you mean by materials?
So the recognition.
And was that the recognition itself plus the accompanying documents, or was it only the recognition?
No, the accompanying documents are part of the recognition.
So the full thing?
The full thing is the recognition.
And do you remember anything about the meeting?
I remember a number of meetings in the Lord Advocate's office about this case. The ones that stick in my mind are the ones where there was a whole team of people. I remember that there were meetings subsequent to the issue of my CCI with regard to next steps. I think even before issuing my CCI, there might have been meetings with regards to the further work that were required as part of the whole investigation. So in other words, is it going to go to FAI and further work requires to be done for that, or are these issues for a public inquiry? So I remember all those, and I remember the discussions in those particular bigger meetings, but I don't remember specifically the discussion between me and the Lord Advocate. If it was a one-to-one, I don't remember that.
Do you remember if you prepared any notes or an agenda, or were any minutes prepared, or anything prepared by you to allow you to prepare yourself for that discussion or that meeting?
I think the report would be the basis of the discussions. So my report to the Lord Advocate will be the basis of the discussions. I don't remember at that time with regard to note takers. Usually now in any meeting that I have, or it's certainly a wider meeting that I have with the Lord Advocate, there's always somebody from the private office who's taking notes, and the same thing happens at law officers briefing. But I don't remember whether that was an informal discussion or a formal meeting with a number of personnel and a formal note taker.
So you've said you can't remember the meeting, but is there any part of you that recollects whether race was discussed, racial motivation, racial tropes, racial stereotypes, terrorism, or any of that type of topic?
No, because I can't remember the actual discussion. I did see in the material that there was an official instruction that came out from private office with post that meeting, which instructed me via the private office to have a consultation with the OST expert. And I've seen that in the materials recently.
And do you remember what was the purpose of the consultation?
No, and I don't think the instruction is pretty brief. I think it's only from memory a couple of lines.
All right. And you did subsequently consult?
I did.
Thank you. I was going to move on to ask you some questions about consultations. We've heard evidence about something called the Precognoser's Handbook Fiona Carnan and Les Brown have given evidence about that. There is a chapter, we can have it on the screen, COPFS 05681. 05681. It's a chapter entitled Expert Witness, and I don't know if you've seen that or you're familiar with it in any way.
I'm aware of the Precognoser's Handbook. I haven't studied it recently, but I'm aware of its content. It is a source of knowledge that's available on the knowledge bank should I require to look at anything in particular. I did start out my career with COPFS, and I was at one stage a fiscal deputy in Dundee, so I did do a limited amount of High Court precognitions for submitting to Crown Office.
So you've actually been a precognoser yourself?
I have.
Legally qualified?
Yes.
In the
not,
past?
Yes, not for a very long time, but yes, I did do a short period as a fiscal deputy.
Thank you. Could we look briefly at page 3, paragraph 4? This chapter of the handbook gives some guidance to precognosers about experts and the use that's made of experts. I'm interested in where it is at the start of there. Although not essential, it's obviously useful if a report can be produced by the expert witness, which can be listed as a production and which she or he will be able to speak to in court. Such a report should contain information on the following points: the witness's qualifications and experience and expertise, the factual basis on which the views are based, the conclusions, the reasons for discounting other explanations. And it says a good report will also set out clearly, if appropriate, the scientific background and the presumptions on which his conclusion are based. If the report is lacking in any such respect, then this should be made good by precognition. And would you agree that that is good practice, primarily to obtain that information from an expert, either in the report or at precognition, or by an AD in a consultation?
So this, I understand, is instructions to a precognoser with regard to what an expert report should look like.
Yeah.
So when the precognoser is looking at the report, then those are the things that should be in the report. If they're not in the report, then sometimes the reports come in draft form, and so there's the opportunity to have a further report. Often the draft form now will be disclosable, so it's not something that causes a problem, but you can go back to the expert and say, actually, no, could you include X, Y, and Z in the report? So this is at an early stage, and this is part of the preparation of the precognition. I think basically this is targeted at post-petition precognitions. So preparing cases once there is a decision on criminality, and the cases are being prepared, in my experience, for Crown Counsel for the High Court. So it's being prepared in High Court format.
And would it be your expectation that a precognoser would be ensuring that an expert was suitably qualified and experienced in order to provide an opinion?
Yes.
And in terms of determining whether the expert witness is fully qualified and has the necessary experience, is that something you would expect the precognoser to do or someone else?
I think it depends on each individual case and the team that's preparing the case for precognition. Sometimes it might be the precognoser, sometimes it might be the senior legal manager, the person who's in charge of the precognosers. Sometimes it might be Crown Counsel. Crown Counsel who's suggesting a witness, or Crown Counsel who's involved in areas that are difficult to get a witness. A Crown Counsel might bring their own experience to bear on experts that they've come across in the past, or you might ask one of your colleagues to suggest witnesses. So those are all the circumstances where it's important to identify an expert with the correct expertise. As
part of this, work being carried out by the precognoser, would you also expect them to determine whether the expert was conflicted, whether there were any possible conflicts of interest that should be addressed, anything of that sort?
That will all, in my experience, be bottomed out at the time of choosing the expert, and that's sometimes why it's difficult to get experts, because you go through that process and experts are put to one side because of one reason or another.
Of potential conflicts?
Yes. Or for example, the defence already have that expert, and so that expert's not available to the Crown.
Right, thank you.
And that's this sort of situation I'm thinking about, is at the stage where you have criminality and you're looking to indict.
When there's an allocated AD involved, as there was in the death of Mr. Biles' investigation, do the roles or responsibilities of the precognoser regarding the expert alter?
No, I don't think so. As we've discussed earlier in my evidence, a lot of the investigations are fact-specific with regard to the makeup of the team and who's leading on it and the stage that it's at. And as I've indicated, this is a pre-petition precognition, so slightly different.
And when you use the phrase, it depends who's leading on it, who was leading on this investigation in relation to Mr. Bile?
When I came into it, which was quite considerably far down the line, there was already the team in place. That there had been significant input from some of the senior civil service and from 2 Lord Advocates. So lots of input at the point I came in.
Who would you say was leading the investigation prior to your involvement?
I think to a certain extent, Les Brown was leading on the day-to-day elements of the investigation.
And after you became the allocated AD here, who was leading?
Still Les Brown.
Still. So at any point were you leading the investigation?
No, because I'm not a precognoser and not part of the precognition team. And as we've discussed earlier, it's very important for Crown Counsel to remain independent of that process.
Thank you. And then can I ask you to look at another document, please? COPFS 05687. And this is Serious and Complex Case Guidance, Chapter 8, which relates to expert evidence and the role of expert witnesses. I'm interested in particular on page 8 of this document. And particularly 8.6.1. So consultation with an expert witness, background. There is, you see second paragraph, there is a presumption that Crown experts will be consulted with in High Court cases.
Okay. And if we can just pause there, this at this stage was not a High Court case because we'd not got to the stage of establishing criminality, so this was a pre-petition precognition.
So this guidance here about a presumption that consultations would take place did not apply to this particular situation with Mr. Bile?
I don't think so, because this is in the precognition of a High Court case in High Court format. So this is what we now have, something called the minimum standards, and Crown Counsel have inputted into those minimum standards, and the minimum standards are what Crown Counsel expects to come to them in a High Court case. But this is prior to that document, and this is setting out to precognosers what Crown Counsel is looking for in the preparation of a High Court case. So a case that's coming to them to prosecute or potentially to indict.
Sorry. What is then the normal practice or the expectation in relation to consultations with experts in the case that you were dealing with here regarding the death of Mr. Bile?
I think that phrase, there is a presumption that Crown experts will be consulted with in High Court cases, I'm not sure that particularly specifically applies in pre-petition precognitions. The pre-petition precognition is to look for potential criminality. so that we can then lead to the stage, if there is criminality, then there would be placing an accused or accused on petition. I think for pre-petition precognitions, it's targeted as to what is necessary in that particular circumstance.
And who decides in relation to that situation, such as that involving the death of Mr. Bile, what consultations are necessary in the circumstances? Whose decision is that?
I think that will be part of the case preparation team as they're going along. If there are issues with regard to the reports, and there was reports that were already in place when I came in, but there were subsequent reports. I probably got them at the same time as the precognoser. If there were issues, it was perfectly open to me to say, go back and speak to that witness. I think some of the witnesses were precognosed before reporting to me, but the expert witnesses, but I'm not able to tell you which ones. But if I wanted something at that early stage clarified, or I spotted something, or the case preparer, or the SLM, or the person directing the investigation, wanted something clarified, they could either go ahead and precognose the expert or come to me and we could discuss it.
In terms of consultations with experts, whose decision would it be in terms of whether it was necessary to consult with an expert at that stage?
At the stage before it was reported to me?
Yes.
Once they were preparing the precognition before it's reported to me.
All right, well, let's deal with it in two phases. Prior to you actually being an allocated AD, who decides whether or not it's necessary to consult with an expert?
The case preparation team. And that's really what's anticipated in that document, even though it's not for pre-petition, particularly targeted at pre-petition. That is targeted at the
Once you
precognoser.
became the allocated AD, who would decide whether it was necessary to consult with an expert?
If it was in advance of providing me with the precognition, then it was the case preparers, so the team.
Would you be expected to attend that consultation?
Not necessarily, no. There would be subsequent consultations where I would attend. So in the preparation of the precognition, so for example, I didn't know any of the details, or I've not seen the precognition, I'm not involved as we go along. This would be done entirely independently of Crown Counsel, and precognitions in the format that's anticipated here of experts would be part of the full precognition.
This is about a presumption experts will be consulted with. Are you saying that, what was the practice in terms of consulting with experts? Not simply precognosing them, but consulting with them prior to a case, prior to petition, prior to case going to the High Court? What was the normal practice?
The normal practice would be the preparation of a case post-petition. So the case will be prepared after a person has appeared on petition, and then it will be provided, a precognition will be provided to Crown Counsel. Crown Counsel will make a decision on criminality. The case will be indicted, and thereafter the Crown Counsel would take that case through the various court stages. So at the stage of reporting, post-petition, before the decision on indicting, the precognitions will be subject to the presumption here that the experts would be precognosed by the case preparers, and a full note. There's a format on how that precognition is or that consultation is recorded. Precognition.
So was the expectation that there wouldn't be consultations with the experts until after the case has been indicted?
Well, I guess it's maybe a confusion on terminology. In the normal run of events, an expert will report. The precognoser will look at the expert's reports. There is, of course, and this is post-petition, there is the presumption that that expert will be consulted and the notes or the precognition is taken. So if we're talking about a homicide and we're talking about a pathologist being spoken to, then the Crown Council would expect there to be a precognition usually, or a consultation and a precognition of the pathologist by the time it comes to us for reporting.
Right. Thank you. And then in the next paragraph, it says case investigators should aim to consult with Crown expert witnesses prior to the case being reported to Crown Office for Crown Council's instructions and indicting, which I think is what
I think
you
that's
said.
what I've just said, yes.
And then where an allocated AD has been identified, then the consultation should ideally be conducted with that allocated AD and the case investigator both present. Do you see that?
I do. And in my experience, that often happens once the AD has the papers, the precognition, and the consultation then takes place with the advocate depute and the case preparer present.
And who's the case preparer or case investigator, as is stipulated there? Is that the precognoser?
It is. So that's Alistair MacLeod and Erin Campbell.
Or would it include Fiona Carnan?
Not in this case, because that's not part of what she did as far as I'm aware. She didn't come in at that phase where the evidence was being gathered, analysed and the further statements taken. I don't actually recall whether there were any consultations with the experts prior to the case being reported to me, prior to the precognition being received by me.
Right.
There may have been, I just don't recall.
Is this an example of where there may be some disadvantage if the narrative and the analysis are prepared by different people? Where perhaps Alistair MacLeod, who prepared the narrative, could be involved in a consultation with an expert, but Fiona Carnan, who prepared the analysis, would not be.
Yes.
And was there the expectation that the person who attended the consultation with the expert would prepare detailed notes?
Yes, but not in the way that is anticipated in the preparation of the precognition, because the purpose of consultation with an advocate depute is different from the purpose of preparing the precognition for the advocate depute. So the way that it's anticipated it would be set out and recorded in the pro forma form is for preparation of the precognition and for presenting that as part of the precognition to council.
So for an allocated advocate depute who is attending a consultation with an expert, where you have the Crown precognition and you're attending an expert, what is the role of that advocate depute?
If you're asking me specifically about the consultations that took place in this case...
I will in a minute.
Okay. So can you ask me the question again? Sorry.
Yes, I can find out the copy of it. Essentially, I was asking you a general question about the role of an advocate depute who's received a Crown precognition, a bundle of papers, and instruction effectively to attend a consultation with an expert. What is the role of that advocate depute? What are they doing? What are they trying to achieve by meeting with that expert?
So if we're talking about post-petition, advocate depute already has all the papers, the precognition, everything's prepared that the case preparer wants to give to the advocate depute. The advocate depute has read that precognition. If the consultation is pre-decision or pre-service of the indictment, then it is to inform the advocate depute with regard to further information that's not clear from the report or from the papers.
And if it's after the indictment's been served, before the trial?
It's in preparation for the trial. And at that stage, it may be even more focused because it will involve the types of things that we were discussing this morning, which is different hypotheses with regards to the factual matrix. If that's put to you What would you say about that? What about X? What about Y? That's the kind of thing, by the time you are post-indictment and you're preparing for a trial, an advocate depute wants to really fully explore.
Could you not be exploring that in advance of the indictment? If alternative factual scenarios have presented themselves through the investigation?
You could be. It really depends on each individual case. You could be looking pre-making a decision, post-indictment, post-petition, but pre-indictment. You could be looking at things that are going to factor in as to whether you're going to mark this case to proceed, whether there's a sufficiency of evidence, whether you have in fact got the correct forum, whether it should be a high court, or whether it's something that perhaps should be marked to go to sheriff and jury. All those things pre-indictment are potentials, whereas by the time you're post-indictment, you are really focusing in with trial goggles as to what is going to happen at the trial.
Could we look at the bottom of page 8, please? And it talks about, in solemn cases, there's a presumption that a consultation should be conducted with all Crown expert witnesses, including expert medical witnesses, unless the evidence relates to routine forensic analysis of drugs. Confirmation has been provided by the defence that the evidence will be the subject of agreement, or a satisfactory statement from a medical witness has been submitted by the police in accordance with the serious crime protocol. Would you agree with that assertion?
At the
that
stage
guidance?
that this document is talking about, because we're talking about post-petition, because already we have a defence counsel or an identified accused.
So post-petition, there is a presumption that a consultation will be carried out with all the Crown expert witnesses, including expert medical witnesses. Before the petition, before the decision's been made to whether to prosecute or not, is there a presumption along those lines, or is there any expectation along those lines?
I'm not sure whether there is guidance or documentation that deals specifically with pre-petition precognitions. I'll be directed to by you if there is.
Is there a practice akin to what you've described a moment ago, that a decision will be taken as to whether it's necessary to consult with an expert,
Absolutely.
medical or otherwise?
Absolutely, because what we're wanting to do pre-petition is really, we're going through the same process, we just have a slightly different focus because we're looking at all aspects of potential criminality. We want an in-depth but also quite a wide investigation in pre-petition. On the other hand, there might be some pre-petition investigations when we're looking at a very, very specific thing, and all that we need is the precognition of one witness or the examination of 2 or 3 witnesses. That might be a situation where Crown Counsel will say, I'm not making a decision to put this person on petition until you go and provide me with information with regard to X, Y, and Z. So it can be quite focused and quite short, or it can be very lengthy.
Now, as allocated AD in the particular investigation we're talking about into Mr. Bio's death, what input did you have from the point you became allocated AD into which experts were to be consulted with?
I'm not sure that I had any particular input into which experts would be consulted with pre-submission of the precognition.
Right. Do you remember any discussions with you about who should we consult with, or do you wish to consult with this expert or another expert?
By the time I had the precognition, read all the materials, I knew which experts I needed to consult with because I knew where the gaps in my knowledge or my understanding were.
So at that point in 2018, was it your decision who was selected to have a consultation with?
Post submission of the precognition to me, yes, and my reading of the material that I had. What I don't remember is, as part of the preparation of the document, the set of case papers, was whether the case preparation team consulted and precognosed any of the expert witnesses. That might have happened, but I don't recall.
And I think you said earlier this morning that you received the precognition in early 2018. Is that right?
I did. I think certainly at the meeting in Hamilton in the January, which was actually the period that I had been allocated to do the reading, there was a discussion which I've seen in the materials, which suggested that the precognition, or at least parts of it, would come to me by the end of February, beginning of March.
Now, we've heard evidence about some of the experts who were instructed in the period after the final PERC report was received by Crown Office. So after August 2016, when you were allocated AD. And during that period in 2017 actually, between the March and the August, there were 3 experts instructed: a Professor Anthony Fremont, who was an osteoarticular pathologist, a Dr. William Lawler, a forensic pathologist, and a Professor Michael Edelston, a clinical toxicologist and pharmacologist. And the evidence we've heard in relation to Professor Fremont was that he was instructed to explore the issue of the fractured rib. Now, that was not part of the cause of death, but the Crown, as I understand it, were interested in the fractured rib because it may have had an impact on the level of force used and in terms of the timing of the fracture.
Levels of force and also the methods used. So it might have helped us with regard to this idea that there was potentially officers kneeling on Mr. Bio's back. So those were the kind of things that we wanted to look at with regard to the fracture. And my recollection was it was in an unusual position for a fracture. If I remember correctly, it was a first rib.
Yes, that's correct. Now, we've heard that Professor Fremont, being an osteoarticular pathologist, that's a particular niche area of pathology, that it's a rare expertise for an expert to have. And he gave evidence that when he retired, and I summarise, the Home Office asked him to return to train the next generation because there was a concern that there was no one in the UK that could take his place. Were you aware of any of that?
I was aware of all that because it was me that had suggested Professor Fremont. And in fact, in the months before, I had been down consulting with him with regard to a non-accidental death, non-accidental head injury and a previous death of a baby. So I had consulted with him in detail. I had also been conducted a number of cases where I'd been the allocated advocate depute, where we had difficulty in finding a replacement for Professor Fremont once he had retired. And if my recollection is correct, it was Dr. Mangum, I think, that took over from him.
Thank you. You anticipated the question I was going to ask. Les Brown had given evidence that Professor Fremont was identified because of your prior involvement with him as a witness in another trial that you'd conducted. Mm-hmm. And that was how he was ultimately instructed and identified by the team.
It was in fact a trial that I was conducting at the time of Mr. Bio's death, so it was a 8 or 9 week trial in the summer of 2015.
Thank you. Can I ask you about Dr. Lawler? Dr. William Lawler, he was a forensic pathologist. Now, we've heard that is the same role as Dr. Shearer and Buhadir, who conducted the post-mortem on Mr. Bio, and also the same expertise as Drs. Carey and Dr. Crane. And I'm interested in the instruction of Dr. Lawler. Les Brown gave evidence about his instruction, and he said he described him as a reviewing pathologist. And as I've been listening to your evidence today, I think you maybe used a phrase along those lines. you said he had been suggested, or that course of action had been suggested by the Lord Advocate at an early stage, and that is how Professor Lawler's name came up. At that time, the Crown Council were wanting to identify a reviewing pathologist, and the full CV of Professor Lawler was forwarded to Ashley Edwards, and she considered that and approved an approach being made to Dr. Lawler. Now, I'm interested in how Dr. Lawler came to be identified and what the purpose of his instruction was.
I don't remember how he finally came to be identified, but I think the precognition team did a lot of investigations into the correct expert to carry out the process of reviewing all the expert reports that we had, because we had quite a range of expert reports from recollection, a lot of them covering the same material, maybe having the same qualifications but stepping outside their own area perhaps of expertise, and that's not a criticism. I think it was they were asked the particular questions and perhaps they weren't the ideal experts. So in the question that you asked me earlier about the instruction of the pharmacologist and the toxicologist, I recall having a discussion and identifying that actually the information that we had on pharmacology and toxicology was not sufficient because the expert didn't have the qualifications, and so we really needed someone specifically with regard to toxicology and pharmacology. The second one was Professor Freeman. I don't remember who the third one was that you mentioned. I think he might have been emergency
Edelston.
Edelston. Was Edelston
clinical toxicology and pharmacology.
Okay, and there was another one that you mentioned, a third one as well.
Lawler.
Okay, so he was the reviewing. We thought would be the reviewing pathologist.
I know you said earlier today you'd looked at the evidence or some of the evidence of Les Brown, so you may be able to anticipate the questions I'm about to ask you. But in relation to Dr. Lawler, first of all, do you remember if the suggestion came from a Lord Advocate that there should be a reviewing pathologist, or was it from someone else?
I don't remember if it was the Lord Advocate or if it was me that suggested a reviewing pathologist. If the Lord Advocate said it was him, that's fine. I'm happy to take that one.
I think it's fair to say the chair has differing versions available to him.
It's certainly a process which I had employed in the trials that I was talking about with regard to baby deaths and non-accidental head injury.
Can you explain to the chair what what you envisaged a reviewing pathologist would do?
Okay, I was seeing a lot of expert evidence which covered, as I indicated, not the fault of the experts, but they were asked questions that perhaps were not covered in their area of expertise, which meant that we had the original pathology report, and then we had a lot of other expert reports from memory that kind of skirted around the pathology. So we had a great deal of reports, but not particularly targeted. And I needed to find my way through all those reports and what they actually meant at the end of the day. The idea of a reviewing expert is certainly something that I've used in cases involving non-accidental injury to children, in particular a reviewing paediatrician. The purpose of reviewing all of the reports, everything that we had, was to try and pull together what we had. It wasn't necessarily someone that was going to give evidence in court, but someone who could assist us with the potentially plethora of reports that we had.
So was the expectation that they would simply come in and review every single report that you had available?
I think they were given, I think Dr. Lawler.
Dr. Lawler, yeah.
Dr. Lawler was given all the reports that we had, including supplementary reports. And that process that I had anticipated he would go through is pretty much what a pathologist does on preparation of the autopsy report, which is go through their own investigation, produce a draft report, wait for the information from subsequent experts like neuropathology, histopathology, toxicology. The pathologist, as I understand their job from consulting with them, will look towards those supplementary reports, and if required will reflect them in their final autopsy report.
And was the expectation that it would be all pathologists' reports that Dr. Lawler would look at, or all experts with some connection with pathology?
All experts with some connection with pathology, because that's the understanding, my understanding of the process that the original pathologists would do. So routinely at the end of their report you'll find reference to neuropathology, toxicology, histopathology, biochemistry, those kind of things. And so that's the process that I had envisaged Dr. Lawler would carry out.
You mentioned toxicology. Did you consider that to be akin to pathology? You just said toxicology there.
No, sorry. The pathologists will look at the reports from all those different experts before they have their final report. So the pathologist will look at the neuropathology report, which will be usually in my experience, a different doctor. The pathologist, the original attending pathologist, the doctors who carry out the autopsy, will, before issuing their final report, take into account all the other expert reports which they have instructed on the back of their examination before they produce their final report.
Let's look at the letter of instruction, please, which is COPFS 04503A. My understanding, this is a letter of instruction from the Crown to Dr. Lawler, dated 28th March 2017. So this is after the Crown Recognition has been sent to you. This is before the Crown Recognition has been sent to you. That didn't happen until the following year, 2018. So it's a letter to Dr. Lawler, and if we can just go down the page, there's some explanation about what Crown Office are looking into. Evidence suggests that during the restraint, Mr. Bio lost consciousness, went into respiratory and then cardiac arrest and was pronounced dead. And it talks about the interim post-mortem. Following the post-mortem examination, a skeletal survey was undertaken.
Not sure. I am following you now. I can see it's in the middle of the page now.
I'm just very quickly scanning through. If I'm going too quickly, we can stop. Further toxicological investigations revealed the presence of alcohol, MDMA, and a drug known as alpha-PVP within the blood, and the cause of death was then amended to sudden death in a man intoxicated by MDMA, ecstasy, and alpha-PVP whilst being restrained. At that stage.
And that is an example of what I was explaining earlier as my understanding of what pathologists do before they produce their final report. And here there is an acknowledgement that following the toxicology report, there was in fact an amendment to the cause of death in the final report.
We've heard evidence from Dr. Shearer that after the post-mortem was carried out, there was an interim, if you like, post-mortem report prepared, where cause of death was described as unascertained. And at that stage it was pending further results from toxicology. So Dr. Shearer explained in evidence that she had taken samples and they had been sent to other experts to carry out the process of analysis of that blood and the contents of that, and she then incorporated those findings back into her report.
And I think that's an example of what I was trying to explain earlier about the process that pathologists go through before issuing their final report.
Right. Dr. Shearer was not being asked to review the methodology or the results or the findings of the toxicologist. She was incorporating those findings into her post-mortem report. Is that the process that you expected, that other reports would be incorporated into a final report by Dr. Lawler? Do you see, I'm trying to explain, I'm trying to get you to explain the different expectations.
I do, but Dr. Lawler is not producing a post-mortem report.
No,
That
he's a pathologist, however.
He is a pathologist, and if he had conducted the post-mortem, then he would have produced a report in the same way as you've just described, Dr. Shearer described to you. So I think what I was trying to explain was that that's a process taking into account the different results or different reports, different findings. That's a process that the pathologist goes through before producing a final report. So I think that was all I was trying to draw an association with.
Right. Can you explain, obviously we can see with Dr. Shearer and Dr. Buhadir, they're gathering in, they're having analysis, independent tests carried out, gathering in the results of those and incorporating them into a final post-mortem report, which is then presented. What was the role and the expectation of Dr. Lawler, who wasn't carrying out an autopsy or a post-mortem? He was a pathologist, however, he is a forensic pathologist. What were your expectations of him in relation to his instruction? Because it was clearly not the same as the process being carried out by Dr. Shearer.
No, but it was from the process that we've gone through, that pathologists go through to produce their final report. It was a similar process that we were asking the pathologist to do, which was look at the extra information that we've now got and give us an opinion, if you can, about the extra information. Is it something that you would take into account if you were doing the post-mortem? Does it change anything? How do the expert reports interact with each other? Just giving us a bit of assistance as to into pooling everything together, because we did have rather a lot of reports, some of them saying differing things about exactly the same circumstances.
All right.
And it was really just a bit of assistance into how we looked at that and how we judged them.
Right. So at the bottom of this letter it says, as part of our, this is the letter of instruction to Dr. Lawler, as part of our investigations, Crown Officer attempting to clarify the role that restraint played in the cause of Mr. Bayo's death. And then we can move on. While it's apparent the fracture to the left first rib will not have caused death, it may be of some significance in establishing the force and mechanism of restraint used by the police officers. A report has been requested from an osteoarticular pathologist in relation to the possible mechanism of the rib fracture in light of the circumstances spoken to by the witness. This will of course be shared by you in due course. Following direction from the Lord Advocate, PERC sought opinion from a number of medical experts on the cause of death, potential contributory factors, and on the use of force and restraint by police. And so again, if we move just to the bottom of the previous page, we'll see that there seems to be a focus. Crown Officer attempting to clarify the role that restraint played in the cause of Mr. Bayo's death. And then moving down onto the next page, following direction from the Lord Advocate, PERC sought opinion from a number of medical experts on the cause of death and potential contributory factors. And I'm interested in, given your evidence earlier this morning, cause of death was a given. you were satisfied in relation to cause of death.
I think I
What
was
was the-
satisfied with the causal link. I'm not sure that I said that I was satisfied at that stage, which is a year earlier, which is March 2017. We're still in the throes of the
Well,
investigation.
Can you explain what the distinction is here in relation to the further investigations and the exploration of the cause of death and the potential contributory factors, and what you were seeking to achieve in relation to that aspect with Dr. Lawler?
We were trying to tease out what had contributed to Mr. Bio's death. We were looking at that stage, and that's a much earlier stage. That's some, I think, 4 or 5 months after I first became involved, because it's early 2017. And so at that stage, we were still looking to see if asphyxia was an issue.
Sorry, can I stop you there? I maybe misheard. My understanding is you were the allocated AT in August 2016.
And this is March of
2017.
17, yes.
So you were involved at this time,
It
weren't
was
you?
just a matter of months after I'd been involved, so
Right.
just an early.
Thank you, sorry.
My arithmetic was not very good. I thought it was about 4 months, but maybe it's a bit longer than that.
All right.
But certainly it's the early part of 2017.
So it's 2017, and I'm really interested in trying to understand what you were seeking to clarify in relation to cause of death.
I wanted to know about the possibility of asphyxia, mechanical asphyxia, positional asphyxia, and the reason that Dr. Lawler was asked those questions was I had understood that he was a Home Office pathologist and he had been involved in the Hillsborough disaster. So he had some expertise in the findings of mechanical asphyxia at post-mortem. And that's the kind of things that we were trying to tease out at that early stage, because those were important from a point of establishing a causal link.
And if we could look up, you say they were important in establishing a causal link, and with what? What was the causal link? With the restraint
and the death.
With the restraint and the death. So you were trying to clarify that there was a causal link between the restraint and the death.
Absolutely. And initially it was thought that the causal link was asphyxia.
Mm-hmm.
And it became clear that once the further experts reports had been obtained, and consultation with Dr. Lawler, that perhaps it was not causal, it was not asphyxia, which was the mechanism of death, but perhaps some sort of cardiac arrhythmia.
Can we go up to the previous page, please? And stop there, please. This, the cause of death is stipulated here in the second last paragraph that we see on the screen. This was the amended cause of death after the final post-mortem report came out. Sudden death in a man intoxicated by MDMA ecstasy and alpha PVP whilst being restrained. So restrained is specifically mentioned in the cause of death. Was that not sufficient for you to recognise that there was a causal link between the death and the restraint?
No, it was important for me from a potential criminal prosecution point of view to know what the difference, what the mechanism was, as much as I could understand. So it would be important to know whether the circumstances of the restraint led to the death as a result of asphyxia, or as a result, I think you of course have heard from the experts, but my understanding was that it finally came down to a potential cardiac event as a result of the drugs which Mr. Bayo had in his system, and the fact that he was struggling during the restraint, and there was a greater requirement for oxygen, as I understand it, and that could have contributed to the cardiac issue.
In your answer, are you trying to diminish in some way the impact of restraint and emphasise the impact of the struggle against restraint?
Absolutely not.
No.
The two are the same. The restraint is the restraint.
Okay.
But it was important from my point of view to understand whether the death has resulted from the restraint because of asphyxia, which is the mechanism, or because of something else.
I think we'll have to come back to this tomorrow if that's an appropriate time.
We'll continue with your evidence at 10 o'clock tomorrow morning.